In this voice thread, I am mainly going to get into the cases, but I will also talk about some kind of like broader rules involving the Fourth Amendment. And then at the end, because there are always these kinds of questions, I'm going to touch on a few sort of like strange cases, right? So, for instance, what about a motorhome? Is a motorhome a house or is it a car? How do we treat it? Do dead people have Fourth Amendment rights? So, we will touch on some of those odd questions at the end, but first, we're going to cover some of the basics, including automobile searches, different kinds of equipment, right? Like what this is in part determining what constitutes a search for Fourth Amendment purposes. Um, but we're also going to talk about warrants, right? So we've talked a lot about, like what's permitted, what's not permitted in the first voice thread. But often the question that we're actually asking is, what do you need a warrant for, right? So we're going to talk about warrants, we're going to talk about warrant exceptions, and then we're going to talk about what happens when a search goes forward that was found later to be unconstitutional, right? So you may have, seen like police procedurals or movies, or had some sort of experience with this in the past, but the answer to that is the exclusionary rule applies, right? So the exclusionary rule holds that evidence that is gathered in violation of the Fourth Amendment in most circumstances will not be admissible in court, right? So we're going to kind of talk about the road to the exclusionary rule in addition to warrants and then some specific cases. Just as a brief recap from the last voice thread, remember there are these two key historic cases. Olmsted, which really tied First Amendment rights to spaces, right, and was very dependent on the idea of trespass. And then Katz. So Katz is more or less the basis of what the court uses now, right? So the question they're always asking is there a reasonable expectation of privacy? There is the argument here that the rights that go with the Fourth Amendment are in fact attached to people and not to places. Now we saw that expanded with Jones, right? So remember, Katz is from the 1960s. A lot of time passed. There have been a lot of technological developments, but then we have Jones decided, and Jones appears to revive the language of trespass. So what Scalia sets down in Jones is that Katz is still good law. The standard is always going to be, is there a reasonable expectation of privacy? However, Scalia says, now the standard is Katz plus, right? So on the one hand, yes, reasonable expectation of privacy, it goes with the person, not the place. That said, we also have, according to Scalia, a reasonable expectation of privacy surrounding our property. So there's a kind of like Katz plus standard in place now since Jones. So as I said, generally when we are talking about what's permitted and what's not permitted, what we're actually asking about is whether or not a warrant is needed, right? So remember, back to the text of the 14th Amendment, it talks about warrants, right, being issued under certain circumstances and not under others. So generally speaking, authorities need a warrant to search your person, your property, your home, right? All of these things that are found to be searches. Now, that said, there are some exceptions, right? So for a lawful search to take place, either there has to be a warrant, right, that has been issued lawfully by a judge, or one of these other circumstances has to apply. So, all right, the first exception is the CETA doctrine, right? This means search incident to a valid arrest. So this is kind of common sense, right? So this is the kind of search that takes place when the person is patted down, right, to make sure that they are not carrying weapons. Additionally, to prevent the destruction of evidence, right? So things that are immediately within reach might be fair game according to the CETA doctrine, because you don't, for instance, want to arrest someone for having contraband and have them, in the process of them being arrested, reach over to the table, toss the contraband out the window, for instance, right? And then also to prevent escape. Now, this is limited, right? So the time is limited, right? You can't, authorities can't use the CETA doctrine to arrest someone and then go back into their house and go through it, for instance, right? So they would need to get a lawful warrant to return to the house and search the premises. So this has to be taking place immediately within the time and also immediately within the area. Now, that said, there's some kind of wiggle room on the CETA doctrine. So for instance, if an officer were arresting you in your living room, and you had within your reach a closed drawer, well, if the officer was concerned that there might, for instance, be a weapon in that drawer, they could open the drawer and look in there. Generally speaking, that wouldn't be permitted because, they don't have a warrant to search that area. So the rules for the CETA doctrine were set by a case called Schimmel versus California from 1969. So this is, you'll note, a Warren era case, right? A lot of these doctrines were established during the Warren era. Second, loss of evidence searches. Again, exactly what it sounds like, to prevent someone from, like a suspect, from destroying evidence. So this is something that has to be justified by there being some sort of pressing circumstances. Now, again, these things are always going to go in front of a judge, and the judge has to decide whether or not the circumstances actually were pressing, or whether, in this particular instance, an officer may have overstepped their authority. Third, consent. So this is fairly obvious, right? So if you agree to a search, then an officer can search your home. This seems obvious and kind of like a silly thing to point out, but you would be surprised how often this happens. Often people will panic. They will not realize that they don't have to consent to have their home searches or searched, and so they consent. They say, "By all means, come on in, officer." And the officer may say, "Is it all right if I look around?" You say yes to this. You have just consented to a search. Now, that said, there is a limit to this, right? So if an officer comes to the door of your apartment while you and your roommates are having a loud party, and you happen to know, that your roommate has, let's say marijuana and, a giant 3-foot bong that, your roommate bought with their stimulus money. So you know that they are in their bedroom. So you tell the officer who comes to the door, "Sure, yeah, it's fine if you want to look around, but, only in the living room," right? So if you set a verbal limit to that, then that does control. Now, for many of you, this is going to be there's also the issue of your landlord, right? So the owner of a property can consent to have it searched. Often, so can a co-resident, right? So if you have, like an idiot roommate, that's something to consider. That impacts your Fourth Amendment rights. Okay, so consent. Consent seems simple. Consent is less simple than it initially sounds. All right, safety. Again, obvious. Limited to immediate threats, right? So that also might apply to, say, the desk drawer that I just used in the example before. So immediate surroundings, again, also time limited. But this might, say, authorize a police officer to go through your pockets and maybe open a zipped pocket, right? If they're concerned that you might have a weapon or some other dangerous thing in it. And then finally, plain view, right? So this one, again, seems sort of like stupid, but again, you'd be surprised how often this ends up being important. So any contraband, any evidence that is readily visible to an officer lawfully present can be seized and used as evidence without a warrant. So again, if you consent to a search, even if you say, like, "Sure, come on in, officer," but please stay in the living room. Well, if your stoner roommate then opens the door to their bedroom and smoke comes billowing out, and the officer turns their head and sees, again, the 3-foot bong that your roommate bought with their stimulus money, then your roommate is in trouble, even though, you, like a good co-resident, tried to limit the access of the officer. All right, so generally speaking, searches require warrants. There are circumstances, under which that is not the case. This is also available, by the way, on page 444 of your text, and it gives a little bit more detail, including a couple of case references, if you are interested in seeing how this has evolved. All right, so we talked about the exceptions to warrants. Now let's talk about how warrants are obtained. So a warrant is issued or not issued by a judge. And so there has to be evidence, right? So remember, as the text of the Fourth Amendment says, warrants are issued upon oath or affirmation. Well, that is interpreted to mean that there has to be sufficient evidence to warrant this intrusion into a person's privacy. So the judge is essentially weighing whether or not that evidence is enough. The term that we use is probable cause, right? So there has to be probable cause. This is a fairly high bar to get over, but there has to be probable cause for a warrant to be issued. Well, what constitutes probable cause? One of the things that might constitute probable cause is a tip from a confidential informant. So we have a couple of cases that deal with this, right? So confidential informants, also known as snitches, can give anonymous tips. Well, what are the potential problems with using anonymous tips as evidence for the purpose of getting warrants, right? I mean, think of the worst possible situation. So suppose, you have a big fight with your partner's really angry. Maybe they call in, an anonymous tip about you. Maybe it's true, maybe it's not. Either way, right, you might have the police at your door. This has been weaponized in certain cases, right? So there have been cases where people have maliciously called in false tips about other people who they've had, for instance, internet disputes with. But this is referred to as swatting, right? And so there have been cases in which people have called in false tips, and this endangers the lives of the people who then have the police at their door, right? So if a SWAT team shows up at your door and they believe that you are armed, you are in great danger for your life. So we could have serious abuses of anonymous tips. So the court considered this, right? So 1964, Aguilar versus Texas. 1964, which court are we looking at? The Warren Court, right? So the Warren Court, in almost all circumstances, expanded the rights of people who were caught up in the criminal justice system, right? So they tended to be less deferential to the state, less deferential to law enforcement than other courts before and since have been. Okay, so Aguilar versus Texas produced a two-pronged rule for using anonymous tips as probable cause. So those tips had to, number one, reveal adequately the informant's basis for knowledge, and number two, to provide facts sufficiently establishing either the veracity of the affiant's informant or alternatively the reliability of the informant's report. That is extremely wordy. So let's unpack this. Okay, so number one, this is pretty straightforward. So the tip had to reveal adequately the informant's basis for knowledge. So some part of the information conveyed to the police had to indicate why the police should believe this person knew this. So for instance, well, I am their neighbor and I can see from my window into their window, that they have a 3-foot tall glass bong. All right, well, you have now also, if you are the neighbor calling in the tip, shame on you. But if you are the neighbor calling in the tip, then you have also now compromised your own anonymity. So Aguilar Spinelli is actually really stringent, right? So it makes calling in an anonymous tip not necessarily anonymous, and so not necessarily cost-free for the confidential informant. Okay, so reveal adequately the informant's basis for knowledge. So they have to give the police some reason to believe that what they're saying, that they would plausibly know the thing that they're claiming to know. Okay, second, to provide facts sufficiently establishing either the veracity, right, of the informant, or alternatively the reliability of the informant's report. Okay, so this is even more information, right? So there has to be even more information establishing that this person is trustworthy. How would you establish that? Well, you might need to say a little bit more about your relationship with the person you're informing on. To establish the reliability of the informant's report, how do you establish your reliability while also remaining anonymous? That's really difficult, right? We usually assess someone who is giving testimony or information. We assess their reliability on the basis of who they are, what their relationship is, to the report that they're making and the person they're reporting on. well, once you have demonstrated all of that, are you really anonymous anymore? Um, so this was a very stringent test, and it made it really difficult to use anonymous tips as probable cause for a search warrant. So the police really did not like this, right? In many states and many jurisdictions, they found this very frustrating. And so eventually this question was revisited in Illinois versus Gates, right? So Illinois versus Gates, which I'll talk a little bit more about in just a second, was a case from 1983. So the court revisited this, considered whether or not Aguilar Spinelli, was too burdensome. Did it interfere too much with the ability of law enforcement to do their job? And so they changed the test, right? So to be clear, Aguilar Spinelli was very protective of citizens' rights, but Aguilar Spinelli is no longer the current test. So Aguilar Spinelli was superseded by Illinois versus Gates. And in Illinois versus Gates, they returned to the standard that existed before 1964, and that is the totality of circumstances standard. That's a much lower standard, right? All that means is that the judge, looking at the totality of circumstances, should make a decision as to whether or not this is probably reliable or not. Well, that's barely a test, right? That's barely a standard. So it's much more permissive. All right, I'm going to delve into Illinois versus Gates just for a moment, give you a little bit more information. So, okay, the relevant facts. The police received an anonymous letter informing them of illegal drug activity by the Gateses. All right, so also, by the way, this letter is partially excerpted in your book in case you're curious as to what the letter said. So after partially verifying the information, the police obtained a warrant and waited for the couple to return from Florida, where they allegedly picked up some drugs and drove back to Illinois. And so the police executed the search warrant and found 350 pounds of marijuana. All right, so the legal question that was raised here is, does a search based on an anonymous tip violate the Fourth Amendment protection against illegal searches and seizures? So the holding 6-3 was no. So they found in favor of Illinois. So the reasoning says that nothing in the letter indicates that the author was reliable or honest, and there's no indication in this letter of the basis for the writer's predictions, right? So, therefore the Illinois Supreme Court applied the Spinelli two-pronged test, and under that test, the letter had to satisfy, both requirements. It had to reveal, quote unquote, like the basis of knowledge, and the letter writer also had to provide some facts establishing their veracity. So the Illinois court found that the veracity and reliability prongs were not satisfied. But the court in Illinois versus Gates says that those two requirements are not entirely separate and independent requirements to be rigidly exacted in every case. So they should be instead understood as intertwined factors that illuminate the quote unquote common sense question of probable cause. Okay. So the court then says, thus we should just look at the totality of circumstances approach, which is more consistent with prior treatment, meaning prior to Aguilar Spinelli, of probable cause than our specific rigid tests. So the court goes on to say that probable cause is, I quote, a fluid concept, end quote. Rigid legal rules are ill-suited to an area of such diversity. As such, the two-pronged test from Aguilar Spinelli is inappropriate. It encourages technical dissection of informants' tips with undue attention focused on isolated issues that cannot be separated from the facts presented to a magistrate. And note this last part, I quote, anonymous tips would seldom survive the Spinelli two-pronged test, but such tips, when accompanied by police work, are quite useful. In this case, the police work supplemented the tip, which ultimately led to the warrant being issued. Okay, so let's look at the reasoning of this. So the court says that essentially the two-pronged test from Aguilar Spinelli is virtually impossible to overcome, right? So they say, and I quote, anonymous tips would seldom survive the Spinelli two-pronged test. But they then go on to say that these tips, when accompanied by quote unquote police work, are quite useful. They say the police work supplemented the tip, which ultimately led to the warrant being issued. But what is the police work, right? So one of the problems with, or the potential problems with Illinois versus Gates is that it is not usefully action guiding, right? So totality of circumstances is really vague, and the suggestion that tips plus police work equal warrant, well, that police work can easily be something that is violating someone's Fourth Amendment rights because it's basically just using the tip as probable cause. So they specifically and explicitly overrule Spinelli Aguilar and Illinois versus Gates and replace it with the totality of circumstances test. Insofar as you can call that as a test, because the court itself describes it as, and I quote, common sense determinations about the possibility of illegal activity being uncovered, unquote. All right, so there were, of course, dissents. So Brennan and Marshall dissent. They argue that a neutral magistrate and not the police need to determine whether there's probable cause, right? That there is, potentially a conflict of interest here. So I want to ask you a question. So I think that it is correct when the court says that the Aguilar-Spinelli test makes it very difficult, almost impossible, to use anonymous tips as probable cause, right, for searches. But what should we take away from that, right? So the court says because, this makes it very difficult to use anonymous tips, therefore we should abandon the Aguilar-Spinelli test. But, isn't there an alternate interpretation here, which is to say, well, look, if you need all of this evidence to establish probable cause, and that's almost impossible to do with an anonymous tip, then doesn't that equally suggest that we ought not to use anonymous tips as probable cause? So what do you think about that? Well, how does this all apply to your lives? Well, obviously things like anonymous tips could become very relevant. Hopefully not, but they could. Same with warrant exceptions. But let's talk about cell phone data, right? So this ends up being really key in a lot of cases, right? In a lot of high-profile cases. So the court has ruled on the use of cell phone data. They did in 2018 in Carpenter versus United States. Okay, so your book doesn't really talk about this, so I'm just going to give you a quick rundown. So in April 2011, police arrested 4 men in connection with a series of armed robberies. One of the men confessed to the crimes and gave the FBI his cell phone number and the numbers of the other participants. The FBI used this information to apply for 3 orders from magistrate judges to obtain, and I quote, transactional records for each of the phone numbers, which the judges granted under the Stored Communications Act. That act provides that the government may require the disclosure of certain telecommunication records when, and I quote, specific and articulable facts show that there are reasonable grounds to believe that the contents of a wire or electronic communication, or the records or other information sought, are relevant and material to an ongoing criminal investigation, end quote. The transactional records obtained by the government included the date and time of calls, and the approximate location where calls began and ended based on their connections to cell towers, right? So this is cell site data. We can refer to this actually as metadata because we're not actually talking here about the content of the conversations, but rather the data about when the conversations took place and about how long they were, where they were made from, right? So as you know, I'm sure if you've followed any kind of true crime podcast or television show, you know that when you make a cell phone call, it's relayed by towers, and those towers can roughly indicate where the phone was located at the time of the call. So this is the kind of data that Carpenter versus US was dealing with. So the question essentially is, okay, so to get this information, does the government need a warrant? On the basis of that cell site evidence, the government charged Timothy Carpenter with, among other offenses, aiding and abetting robbery, right? So that affected interstate commerce, right, in violation of the Hobbs Act. So just as an aside, most of the cases we look at, not that many of them are going to be federal cases because, as I said in the intro video to this unit, most criminal cases in the U.S. are not federal. They take place at the state lower level. But again, this like interstate commerce language you will often see to justify a federal criminal crime or statute. Okay, so Carpenter challenged this, right? So he moved to suppress the evidence, arguing that the FBI needed a warrant to, based on probable cause, to obtain the cell site records. So the district court denied the motion to suppress, so he appealed it further. Sixth Circuit, same, ends up appealing this to the Supreme Court. And what did the court find? Well, they found that the warrantless acquisition of Carpenter's cell site records violated his Fourth Amendment rights against unreasonable searches and seizures, right? So they reaffirm an idea that they have articulated before, right? So most notably perhaps in Katz. And also if you hearken way, way back to Brandeis's dissent in Olmsted, the Fourth Amendment protects not only property interests, but also a reasonable expectation of privacy, right? So as recently as 2018, the court has reaffirmed this standard. So important points about Carpenter v. United States. So yes, they did rule that the government needs to get a warrant to obtain cell site data. However, right, this is just cell site evidence, right, metadata. So it's fairly narrow in what the warrant is needed for. Additionally, this was very narrowly decided, right? This was not one of these unanimous cases where the court spoke, with one voice very forcefully. There were a bunch of different dissents. So one of the questions that came up here is one of the questions I've asked you in the previous voice thread. So expectations of privacy in this age of digital data don't fit neatly into existing precedents, right? So the court found that, tracking a person's movements and location through extensive cell site records is far more intrusive than the precedents might have anticipated. So essentially they're saying, like, it's not reasonable for people to expect this kind of or this kind of tracking, right? That anyone's keeping track of them this way. So you can kind of compare this to the Jones case. Remember where there was a GPS unit on his car and that was seen to be intrusive. But remember, Jones was decided on trespass logic, which has to do with the space, right? So the car had a lot to do with the Jones decision. This is a cell phone. This isn't a place where, where trespass can occur. But rather, this was decided very much on that reasonable expectation of privacy grounds. So again, this raises the question, well, if we're talking about expectations of privacy, as the general public becomes more and more aware of what can be, done with this kind of data, should we be scaling our expectations of privacy accordingly? Or, maybe should the court start coming up with a different standard because that like quote unquote reasonable expectation of privacy might vary a lot more widely than it used to. Again, another interesting point about Carpenter versus United States is that they pushed back against the third party doctrine. So I kind of foreshadowed this in the first voice thread, but so information that's disclosed to a third party carries no reasonable expectation of privacy, right? So when you give your information to the utility company, for instance, you have now disclosed it and you don't have a reasonable expectation of privacy. Your bank, right? So the third party doctrine can really expose can really expose people, honestly, to a lot of invasions of their privacy that they may not see coming, because they think they have this understanding of privacy. With the third party, not necessarily. So the court in this case did not apply the third party doctrine, which is important. Here are the basic parts of the third party doctrine, which I don't think your book talks about. So again, the court chose specifically not to apply this in Carpenter. Had they, however, this is what it looks like. So the third party doctrine tells us that information disclosed to a third party carries no reasonable expectation of privacy. So this was established in US versus Miller, 1976. This includes banks, phone companies, utility companies. So what are the principles? Well, that disclosure must be voluntary. Okay, so, when you get a phone, you sign all kinds of contracts, and there's a lot of fine print, like a lot of fine print. Do you read all of that? Who have you agreed to disclose your information to, right? Like, who are the third parties that are, kind of the weak link in your privacy chain? So the disclosure must be voluntary, but that's a pretty low bar because you probably have initialed and signed all kinds of things you've never read. And it like raises some important questions. So what about internet service providers? Are these a third party? What about cloud data, right? So you just all turned, you've all turned things into Dropbox. You will turn things into Dropbox for this class. So, do you have a reasonable expectation of privacy over what you put in those documents? So, spoiler, no, please don't, confess to any crimes in your midterms. But, like people have a lot of cloud data, Dropbox, iCloud, etc. Unless you're storing everything in like air-gapped, separate physical hard drives, you probably have a lot of your data out there that you have given permission to a third party, to access, whether you realize it or not. So this is all like a huge gap in your Fourth Amendment protections. So federal law has stepped into some of this gap, right? So sometimes, federal statutes are better able to deal with the fine-grained questions of privacy that, the Fourth Amendment just can't, right? Because it is so very broad. And one of the ways that the federal government has dealt with this is through the Stored Communications Act, right? So this is a federal law but it only protects data that's related to electronic communications, right? So, who's sending you emails, when, where are they located, that sort of thing. So that's also like quite limited. So this is something to consider, right? So the third party doctrine ends up being a great big sort of like backdoor in Fourth Amendment protections. How receptive the court is to it varies, and as we saw in Carpenter, they opted not to apply it. Part of the reasoning of Carpenter, and as I said, it's a plurality opinion, there are a ton of dissents, but part of the reasoning for the majority in Carpenter versus US is that times have changed, right? So I mentioned this again, like in the intro video, I talk about this in the last voice thread, but like, where is your information? It's not probably, most of it sitting in a file box. It probably isn't on air-gapped hard drives. Rather, chances are excellent that it is like within your reach right now, right? So almost everything in your life winds up on your phone, and your phone is always on you. So the court is trying to catch up with technology in Carpenter versus US, and acknowledge that, like just this is the way life is now. That most of us have sensitive information on these little teeny tiny handheld computers that we refer to as phones, and therefore, they should be treated differently, right? They aren't just like, someone's wallet. They are akin to, much more private forms of data storage. Okay, so that said, there are also places where Fourth Amendment protections are reduced. So automobiles, right? So this was initially established in Carroll versus Illinois, a case from 1925 when the technology was new, right? So this is a recurring theme in Fourth Amendment cases. New technology blows up everything, right? So it's not clear how the right to be free from unreasonable searches and seizures applies to, say, an automobile, because it's kind of like a room, right? Like, how much of your stuff do you keep in your car? Some people, kind of live out of their cars, and some people literally live in their cars. But also they are in public, right? You drive them around on streets, which are the paradigmatic public thing, or public space. They have these big windows, right? So you can see into them. There's the possibility of destroying evidence, right? So all of these things are articulated in Carroll versus Illinois. The reasoning for treating automobiles differently from, say, the home. Jails and prisons, surprise, right? The persons of prisoners have reduced Fourth Amendment protections, which is why guards can go in and search their cells and search their persons, right, without warrants. Discarded trash, right? So you throw it away, it's not yours anymore. You don't have as high an expectation of privacy. Public schools. So this is covered in your book. So United School District number 1 versus Reading. So students in public schools have drastically reduced Fourth Amendment rights. So the standard for that is not probable cause, but simply reasonableness of the suspicion. Open fields or tracts of undeveloped land, right? So that was established in Oliver versus US. So there are plenty of places where people have reduced privacy. So I'm sorry, reduced Fourth Amendment rights. So one thing I would like to invite you to compare, and I'll also post this on the discussion board, is the case of Hudson versus Palmer and the case of Safford USD number 1 versus Reading. So these are prisoners versus public school students, but compare the reasoning for reducing their Fourth Amendment protections. In both cases, do you think it is reasonable? All right, so I'm just going to say a little bit about Safford Unified School District number 1 versus Reading. So this is a case from 2009. Your book covers it in some detail, but I'm just going to talk a little bit about it here. So on October 8th, 2003, Savannah Redding, who's 13 years old and a student at Safford, this is in Arizona, middle school, was called to Assistant Principal Carrie Wilson's office, where Wilson told Redding several students had claimed that she was giving them prescription strength ibuprofen and giving it to fellow students. Right, so Redding denied it and allowed Wilson to search her backpack, where he found nothing. So Wilson then instructed the administrative assistant, Helen Romero, to take Redding to the school nurse to search her clothes for the pills. So Romero, so this is the principal's administrative assistant, Romero, and the nurse, Peggy Schwalier, asked Redding to remove her jacket, socks, shoes, stretch pants, and t-shirts, right? So none of that clothing had pockets. Finally, Savannah was told to pull her bra out and to the side and shake it, and to pull out the elastic on her underpants, thus exposing her breasts and pelvic area to some degree. No pills were found. April Redding, Savannah's mother, sued the school district and school officials involved for conducting essentially a strip search of her 13-year-old daughter in violation of the Fourth Amendment. So the district court found no violation, but this went to the Ninth Circuit, which is historically more of a sort of it's less deferential to the government, let's say, district, although that's not necessarily still the case. Anyway, so the Ninth Circuit reversed, holding that students have a right to personal privacy that was unreasonably violated here. So the school district, in this case, appealed, and it ended up going to the Supreme Court, which granted certiorari. So the legal question was Savannah Redding's Fourth Amendment right violated by a strip search conducted on the reasonable suspicion that she brought forbidden prescription drugs to school? So were her rights violated? The court held yes. They held 8-1 that the search violated Savannah's Fourth Amendment rights. So Justice Souter delivered the opinion. So he says that the Fourth Amendment requires law enforcement to have probable cause to conduct a search. Now, a previous case, TLO, recognizes that school settings require some balancing of government and private interests that doesn't rise to probable cause. So the standard, therefore, that should be adopted by schools, Souter says, needs to be, and I quote, reasonably related to the objectives of the search. So this is the language of rational basis scrutiny. So lowest level of scrutiny. So Souter says that the measures have to be reasonably related to the objectives of the search, in this case to find drugs, and not excessively intrusive in light of the age and sex of the student and the nature of the infraction, right? So essentially what they're saying is this was not reasonable. This was an excessive response that, it was too much. It was too intrusive given how young she was, and the relative like not serious nature of the infraction, right? This is prescription ibuprofen. This was not someone bringing, for instance, a weapon to school. Um, so the standard for schools, as Souter says, is that there should be a moderate chance of finding evidence of wrongdoing. So this just sets a reasonableness standard, right? So this is not probable cause. This is it's a fairly low bar. Do you think that this case was decided correctly? Do you think that children should have more or, less in terms of Fourth Amendment rights? Okay. Anyway, so these are some of the cases in which reduced Fourth Amendment protections apply. I'm not going to go into all of the details of automobile searches, but suffice it to say, they are complicated, right? So your book addresses these on page 458. And I strongly urge you to take a look at that, right? Because they look at a bunch of different circumstances that end up affecting Fourth Amendment protections. So obviously, Carroll versus U.S. important case because this, establishes the baseline for automobile searches. But also take a look at these other cases because they end up being important in terms of like what areas of the car can be searched, under what circumstances, what constitutes probable cause, right? So they will discuss things like opening containers that are within the car. So all of these end up modifying the finding in Carroll versus U.S. So I had planned to go into, as I mentioned at the beginning of this voice thread, some of the kind of like odd circumstances at the end of this voice thread, but just for the sake of kind of limiting the length of this, I'm going to conclude here. But I'm going to kind of foreshadow what we're going to look at next time. So like I said, we're going to talk about the exclusionary rule, right? So this is what happens if evidence is gathered in violation of the Fourth Amendment. And so we'll talk about how that comes to be and like what the functions of it are. Also the ways in which it's been modified since it was put in place. But we're also going to look at some specific search cases that are covered in your book, right? So for instance, Florida versus Jardines, right, which is the case dealing with the drug dog. We're also going to look at the use of, heat sensing, so like thermal imaging, that's the term, thermal imaging technology, right? So again, like all of these kind of like fine distinctions that end up being made in response to new technologies. So there are a lot of, again, like very fine distinctions being made. But we're also going to talk about Terry stops, right? So you may have heard of these, maybe not referred to as Terry stops, but maybe referred to as stop and frisk. So we're going to look again at some of the exceptions to your Fourth Amendment rights. And then I will, in fact, move to some of these sort of like odd circumstances like motorhomes, the Fourth Amendment rights of dead people, etc.